this webinar. So thank you for joining us today for a webinar focused on UNT visa certification, best practices in investigating and prosecuting cases involving immigrant crime victims. We have three great presenters with us today: Tara Patet from the St. Paul City Attorney's Office, and Michael LaRiviere from the Salem, Massachusetts Police Department, and Leslie Orloff with the National Immigrant Women's Advocacy Project. So with that, I'll get started. I just want to let everyone know that this is being recorded, so we'll share the recording as well as the slides and any resources with all of the attendees following the webinar. And then we are using the chat function for communicating with the panelists. So please utilize that, and there'll be some opportunities to converse and answer some questions as well. And we are happy to answer questions as they come up. So please use that chat function and we'll get your questions answered. I will pass it along to Leslie.
Thank you, everyone. And I appreciate your being here. I'm going to turn it over to Michael to open the webinar.
Thanks, Leslie. Welcome, everyone. We're really excited to have this 2-hour time block with everybody to go over this really important topic and try to help put some of those tools in the toolbox that we all carry on with us when we're out there doing our work. So this is our webinar on the UNT visas for immigrant victims of crime and trafficking. We're going to talk about some best practices in responding to, investigating, and prosecuting cases involving immigrant crime victims. And we're going to focus this on cases of domestic violence and sexual violence.
Next slide, please.
I can't do the slides, I don't think yet.
No, they're going to do the slides.
Yep. Thanks. So this project is supported by a grant awarded by the Office of Violence Against Women under the U.S. Department of Justice. With that, the opinions, findings, conclusions, and recommendations expressed in this publication are those of the author and do not necessarily reflect the violence against the view of the Department of Justice and the Office of Violence Against Women. In short, basically, it doesn't mean that everything I say is something that they agree with. Right, Tara?
Right.
You're darn right.
Wink, wink. All right. So real quick, myself, I was a police officer in Salem, Massachusetts for just a little bit under 31 years and retired about, I don't know, about 4.5 years ago, but still very much involved with the agency in a different role and doing a lot of national training and curriculum development projects around the country, and have spent, I don't know, Leslie, you might know better than me how many years. It's been a long time. We've been
Over a
together.
decade more. I think it's 2007, whatever that is.
So one day I rolled into your conference room and just jumped up in front of the room because I was late and started teaching without even meeting you. I remember that. But yeah, it's worked probably about 20 years nationally, working with some national organizations, federal organizations on this stuff. So I'm really excited to share some of those experiences with everybody. I'm going to turn it over to Leslie and Tara to introduce themselves.
Tara, you want to go first?
Sure. Hi, everyone. My name is Tara Patet. I'm a prosecutor with the St. Paul City Attorney's Office in St. Paul, Minnesota. I have been prosecuting for 28 years, mainly in the areas of domestic violence and elder abuse. I supervise our crimes against persons unit and our victim witness team as well. And I've had the pleasure and opportunity to train nationally on these topics with Mike and Leslie for quite some time. Really looking forward to chatting with you today.
And I'm Leslie Orloff. I direct the National Immigrant Women's Advocacy Project at American University, Washington College of Law. I am essentially former family law attorney. I started my career working with immigrant victims and found myself as the only Spanish speaker in DC who knew what a protection order was in 1983. And have been working with immigrant survivors since then, and had the privilege of being lucky enough to be part of the small team of people in the room when the Violence Against Women Act was written, and was responsible for kind of coordinating the efforts around writing the VAWA self-petition laws, the U visa and the T visa laws. I get really excited about these trainings because the more you all know about these laws and how they work, the more what Congress was trying to do will be effectuated, and the better it is both for your investigations and prosecutions, but also for the lives of victims, as we'll be talking about today. So I'm very happy to be here. Next slide, please.
So our first poll of the day, just want to find out kind of who we have on this webinar with us. We can help us guide our conversations. So if you could just take a second just to let us know what profession you're with based on this poll.
There's law enforcement, prosecutors, systems-based would be the victim advocates or the attorneys the victim advocates working in law enforcement or prosecution offices, child or protective services. And then if you're another organization, if you could put it in the chat and check the box. Rebecca?
So we have about 70% that have responded. So just give it another second and then close it. Alrighty.
So we have mostly the majority is system-based victim service professionals, and then prosecutors 25%, law enforcement 17%, and other. And I can look in the chat here and see, Leslie.
I'm not seeing anything.
Nobody put anything in the chat. So if you get a chance, just if you can let us know, we really like to keep track of, who's out there, who's in the room with us here, and can help us with our conversation as well.
Great. Thank you. Next slide, please. So the National Immigrant Women's Advocacy Project provides training and technical assistance and support to professionals like yourselves, with the idea of not having you have to figure it out from scratch when you're working with an immigrant survivor, and answering the questions to make it easier for you to do your jobs when you're working with immigrant survivors. We do training, technical assistance, we have training materials. We also, since I know a number of you seem to be victim witness staff, we have a community of practice that is designed for both systems-based and NGO-based victim witness people, victim advocates, that we can send you links to. I'll try to find it and put it in the chat. But we can send it to you post-training and encourage you where you can meet with other victim advocates from around the country and get your questions answered and learn from each other. Next slide, please.
So under the projects that we work on together, we do host virtual roundtables. It's an awesome opportunity. We do them in general. We usually try to do one every couple months, and it's law enforcement prosecutors only. We have interactive discussions. We try to build the topics based on the previous roundtable that we had. It's really an open conversation, if you will. We usually have a prosecutor, a law enforcement officer, and then if Leslie's available to join, Leslie will be on there with us. So I really encourage everybody to get on with those and register at the website that you see on here. And I think we're going to be coming out with our next roundtable date in the next week or so.
Okay.
So we look forward to seeing you on there. We just had it. We just had last week roundtable and a question and answer session after that, which went really well.
Great.
Yes.
And it was actually relevant because the webinar, which is available publicly, was on offender-focused prosecutions, which would be a good follow-up to this training as well. Next slide, please.
So we have our learning objectives here. As you can see, we got a lot of stuff that we want to talk about in the 2 hours we have together. So by the end of this webinar, everyone should be able to hold offenders more accountable by using the UNT visa certification process as a crime-fighting tool. We're trying our best to enhance victim safety and participation in the criminal justice system through these certifications and the relief that we'll talk about. When we're doing this, we know that when we're doing this the right way and we're keeping this at the top of our list, we enhance officer and victim safety, community safety, and building trust with the immigrant survivors in our communities. We'll talk a little bit more about that, obviously. And then we can develop trial and trial strategies to overcome common defenses in immigrant victims' cases. And Tara has some slides in here that are going to be really important for the prosecutors that are on the webinar with us today. So you're prepared for some of the things that come up in the courtroom when U-Visa certification, say, was signed prior to the court date to the trial. And any questions we have today, just so we're all on the same page, please help us out so we can really get your questions answered and have a real rich discussion here. Use the chat box. So anything that comes up when we're talking, throw it in there. We're all paying attention to those. So if I'm talking, Tara and Leslie are going to be looking at that chat box to see some questions, and we'll get those things answered. So we appreciate your participation with that.
Great. Next slide, please.
So general caveats, we have women, men, children, and persons of all genders can qualify for a UNT visa. Victims of almost all violent crimes and many other crimes are eligible to apply for U visas. We'll talk about that in detail. We'll show you the list. But the examples that we're going to use today throughout the presentation is mostly going to refer to female victims of domestic violence and sexual assault.
Next slide, please. So we're going to start by just a few real key pointers on, how to effectively communicate with victims of crime who might be limited English proficient. And I want to start off on the next slide with another poll, but this time I'd like you to use the chat box to respond. So next slide, please. So in Maryland, the communities you're working in, what countries are you seeing victims coming from? Can you type in the chat some of the examples of countries, maybe the most common ones and some of the lesser common ones, to give us an idea of what you're seeing? We're going to be asking you to use the chat a couple times, so it'd be good practice now to try. So I'm seeing Guatemala, El Salvador, Honduras, Mexico. Yep, others? And if you're typing in the chat, you'll have to put it to everyone. The Philippines, Dominican Republic, El Salvador and Mexico. Anywhere else? Okay, and any lesser, more unusual ones that you've seen or that you see commonly? I'll give you another second. Okay, let's go to the next slide, as in you can keep typing in countries. 6% roughly of the, it shouldn't be countries, it's of the Maryland population, are foreign born. Of that, 55% are naturalized citizens and 27% are lawful permanent residents, which means that 7.5% are either temporary visa holders or undocumented. And when we talk about the U visa, it's equally open to any non-citizen, any immigrant who is either not a citizen or not a lawful permanent resident. So they could be student visa holders, work visa holders. They could be here lawfully, or they could be here undocumented. This webinar applies to both of them. And the other thing that's really important in Maryland is that 31% of the children in the state who are under the age of 18 have one or more immigrant parents. So you're going to be working with people with mixed immigration status families, quite commonly, like about a third of the time in Maryland. And 85% of children in mixed immigration status families are US citizens. Next slide, please. So Maryland is really interesting. Does undocumented? Yes, undocumented includes both people who entered unlawfully and people who entered lawfully and violated the terms of their visas. And they could violate by overstaying. They could violate by working when they're not supposed to work. Those are the two big categories generally, or by switching employers sometimes when it's tied to an employer. So Maryland's a really interesting state because almost 40% of the state's foreign-born population are from Latin American countries, but almost 30% are from a range of Asian countries. And then you have almost 20% that are from African countries. And I noticed nobody mentioned Ethiopia or Eritrea or Somalia, but we know we have a good sized African population in Maryland, and this number of Europeans is also much higher than we see in most states. So it's almost 9% would look like me and come from a mixed immigration status family like me. My father was an immigrant, but you look and talk to me and you wouldn't look at me and say she's from an immigrant family. And so it's important to understand that there's a lot of diversity, and that 37.8% of the foreign-born population in Maryland are limited English proficient. Next slide, please. And then we have two slides, and these are really for your purview for perusing later on. But I just want you to notice that when we look at languages spoken at home in Maryland, The top three are Spanish, Chinese, Yoruba, Twi, and those West African languages. When you look at limited English of the populations that are limited English proficient in Maryland, next slide, please. What you'll see is that limited English proficient, the percentage of the population that lives in the state's limited English proficient, this list is in a different order and doesn't have the same languages. So, I mean, it doesn't have in the same order. So Vietnamese are more likely and Chinese are more likely than Spanish-speaking population in Maryland to be limited English proficient. Next slide, please.
So what does that mean for us in law enforcement and prosecutors when you have, a large percentage of your population that doesn't speak English as a first language?
I'm going to type in the chat.
Yes, type in the chat and we'll be reviewing that.
Go ahead. Anybody?
All right, we're just going to have everybody put their cameras on and talk then.
We
There
did
you
have a comment, a question. Does undocumented include someone who is a B2 overstay, for example?
I answered that.
Oh,
Thank you,
okay,
Leslie.
sorry.
It does.
Yes,
And-
so the question is, what does it mean for law enforcement and prosecutors when you have a large percentage of your population that doesn't speak English as a first language? And I can see difficulty to communicate is in there. Unwillingness to cooperate. Yes, agreed.
Not understanding the legal system.
Yeah. I'm guessing Jill is meaning that she might have officers that she might utilize that are bilingual to help try to find out what's going on, those types of things. Language barriers, yes. So if you can keep typing those in, we can move on to the next slide and just talk a little bit about what it means for us in the things that we are expected to do. So we, under DOJ model guidelines, are expected to provide free language access to any limited English proficient person who requests it. When we decide if we're doing an investigation or a prosecution, we decide that it's helpful to that investigation, which when wouldn't it be when you're trying to collect evidence and develop probable cause, right? We are required to inform members of the public that it's available free of charge, language assistance, and it's provided in that person's primary language. And we can go to the next. There is a sample here. You can see that website right there. And everybody's going to get these, right? So
Yeah.
there's a sample. Then we can go get a sample policy.
Yeah. Next slide, please.
Next slide. So what is meaningful access? And you can see in quotes here, and this is in quotes, so I will read everything on here. Language assistance that results in accurate, timely, and effective communication at no cost to the LEP individual. For LEP individuals, meaningful access denotes access that is not significantly restricted, delayed, or inferior as compared to programs and activities provided to English proficient individuals. So what does that mean, basically? Those individuals in your community that you interact with in your community that don't speak English as a first language should be able to navigate the conversation with frontline law enforcement officers, the system, resources, all the things that a person who speaks English as a first language could do. And it shouldn't be delayed. So next thing you know, you're waiting 45 minutes or an hour to kind of figure out how you're going to communicate with this person. We should have things in place. And we have tons of resource. The New App Web Library has great resources that can help out with putting this stuff together ahead of time. Next slide, please. So I know for law enforcement, we think about, what does that mean for us when we get a call, and how many calls do we get when we get on scene? And it's all kinds of stuff going on, and you have an individual who's not speaking English and you're having a tough time communicating with them. So exigent circumstances is what that is. Oftentimes, if it's a prosecutor, right, Tara, if it's you and you're doing interviews, preparing for trial, there's probably not going to be exigency floating around there in that office space that you have in your interview. But for frontline law enforcement officers, we see exigency a lot. Example, 911 call, help, my boyfriend just hit me, he strangled me. We send an officer out, officer gets on scene, and there's all kinds of stuff going on, and that person can't communicate with the officer because they speak Vietnamese and the officer only speaks English. In those exigent circumstances, we can use the most reliable temporary interpreter that's available to us to address those exigent circumstances, which would be like, where's bad person? Where'd they go? Where'd they flee? Anybody hurt? Do you need an ambulance? Any weapons involved in this? If you recognize that there's some kind of danger to the officer, the victim, or the public in general, so the person fled and they went into another building and it's an apartment building, you think they might try to get in someone else's house. You can use people that are available to you. And in some cases, and every time I say this, I kind of feel like I get a hiccup in my voice where we can use kids. And, we've taught for years, don't ever use kids when you're interpreting. But in exigent circumstances, if they're the most reliable person that's available to you, it's okay to ask those basic questions. And we have a ton more information on that also in our guides too.
And the way to think about it is you don't want to be asking information that you're going to need for your police report. You're trying to find the weapons. You're trying to keep people safe. You're trying to get people to the hospital. You're trying to figure out who might be the perpetrator. And one of the other things I think it's really important to remember is you could have picked the perpetrator as the interpreter. And so you want to be really careful and just know that that's true so that that you don't just kind of follow down your investigative line.
Right. And that's why sometimes the most reliable temporary interpreter could be, that 12-year-old child, because you now have, a middle-aged man that's the other person that's in the house and things don't feel right. I mean, you have that sense where it's like, I'm not sure this person's going to probably give you the most reliable information.
But I'll add, Mike, when you are using kids, because of exigent,
Excuse me.
really important to circle back. Also, because we know, for example, in sexual assault cases, often a parent isn't going to be as likely to explain to an officer through their child what happened to them. So you may miss things if you don't circle back with a qualified interpreter.
Exactly.
Absolutely. So next slide, please. So the DOJ requirements for investigations and interrogations are the following. So you have that exigent circumstance, like Leslie said, we need to find out bad person, medical attention, weapons, where are they, that type of stuff. We're good. Now we're moving to probable cause. We're moving to investigating, collecting evidence, that type of stuff. Now we have to use a qualified interpreter. Anytime we're doing an interrogation, taking a formal statement, we're talking to suspects, witnesses, talking about legal rights, all that stuff. You can see here it has bullet points, police reports, criminal interrogations, crime witness interviews. The materials that we utilize, which we utilize a lot, and for you too as well, Tara, you have tons of documentation in the prosecutor's office. Those things have to be translated into the primary language of that individual that you're interacting with. So for us, it'd be, Miranda warnings, know your rights, but for the prosecutor's office, it could be all kinds of different things that you're going through and navigating with that person. Next slide, please. So what is a qualified interpreter? And it says here in quotes, when considering whether an interpreter is qualified, the LEP plan, and like I said, we do have examples of that, discourages the use of police officers as interpreters. And I'll tell you, we did this a lot in my agency. I mean, for a good part of my career, I ran a special crimes unit, and we had a handful of Spanish-speaking officers that we would use, and there was a couple that I used very frequently. But they weren't qualified interpreters. Once we start to learn about really what it means to be a qualified interpreter, there has to be some form of training that, they recognize what it means to interpret it, the do's and don'ts. You're not paraphrasing, there's a bunch of little nuances that go into being a qualified interpreter. It's not a certified interpreter course like the courtroom, like Tara and the other prosecutors on this webinar are used to. Like when you're doing interpretation in a court, you have to use a court certified interpreter. It's a lower standard than that, but there still has to be some form of training and understanding as what it means to be an interpreter. Not a dual role like it says here. So, I'm not going to bring in one of the officers to help me out with a interpreter interview, and that officer is going to listen to the answers being given back and ask follow-on questions. They're just acting as that interpreter, the conduit between myself as the investigator, the officer, and that individual that we're interviewing or taking information from.
Right. Exactly. And that's different than when you have a bilingual officer who's investigating their own case. Right. Using an interpreter, they're just functioning in that language.
That would just be like me going in and investigating a case with a person that speaks English.
Right.
Right. So it's a little bit different there. And I'll tell you, just, we're going to kind of shift the conversation a little bit, but it's not hard to get your officers, maybe some civilian staff, some other individuals that identified in the community at other organizations qualified as an interpreter. We did it. We have a list of like 25, 27 qualified interpreters. We have their availability. The OICs, the detective division, the supervisors all have a list. When something happens on the fly and we want an in-person qualified interpreter, we just go through that list. And when all else fails, we have the language line and all the resources that program offers as well.
Great. So I'm going to turn it now over to Tara. Next slide, please.
So we're going to move into a conversation about the UNT visa programs. So let's spend some time first just talking about the sort of the history and the purpose of those programs. Next slide, please.
So this is a shield that was developed by the Department of Homeland Security. There's an updated version in your materials. But I provide this because I want you to understand that when we're talking about U visas, which is a lot of what this is about, and T visas, they're part of a whole, there's lots of different paths to, there's three major paths to legal immigration status. One is through family, another is through work, and the third, which we're talking about largely today, is through humanitarian forms of protection. And so what happens here is that I just want you to understand that there's a whole set of remedies, and I'm going to try to quickly tell you what they are, just so that because you may see cases like this. So anytime you have an abuser who's a U.S. citizen or lawful permanent resident, spouse, parent, step-parent, or former parent, you're looking at something called a VAWA self-petition. And that, as opposed to they are U visa eligible as well, but there's a faster form of relief available if the abuser is the U.S. citizen or lawful permanent resident, as I say, a spouse, parent, step-parent. And then if this abuser is an over 21-year-old citizen child in an elder abuse case, that also qualifies as a VAWA self-petition. Another one that you'll commonly see is, particularly when you've got a domestic violence caseload, you'll have overlap with child abuse. And anytime a child has been abused, abandoned, or neglected by one of their parents, and that abuse, abandonment, or neglect could have happened anywhere in the world, that child is eligible for something called special immigrant juvenile status. The T visa and continued presence are remedies for human trafficking victims where that human trafficking has occurred in the United States. And the U visa that we'll be talking about today covers all of the domestic violence that doesn't fall into the U visa, and sexual assault and stalking and human trafficking and a whole bunch of different other kinds of crimes that we're going to go over in a little bit. But I wanted you to understand that this is part of a package of relief that help immigrant crime victims. Next slide, please.
So let's do another poll. Looking broadly at the different types of relief, of immigration and relief that you saw on the shield, what do you think? Why do you think that these forms of immigration relief exist for victims of crime? And please just type your answers in the chat box. Any ideas on why you think this relief exists? And we can, when you write it in, just make sure it's visible by all, and you're not just going to one person. And yep, multiple ways to get relief. That is true. They're really wanting to make sure that we're getting the most victims that we can. That we're offering stability to the most victims that we can. That so crimes can be reported and prosecuted without victims fearing removal, immigration consequences. That's absolutely right. And encouraging cooperation and participation in both investigation and prosecution. Thank you for those. Next slide, please. So, the main thing is, and you've hit on this, we want to build trust, but also we want victims to trust the system. We don't want, in the U visa context, we don't want victims in our cases to disappear due to deportation while a case is pending. And we're going to get into that more later on in the presentation. We know that victims aren't going to report crime if they think that doing so is going to get them deported. They're also not going to report crime if they fear police just as much or more than they fear the perpetrator. So all of these things are really important, and really what these laws are aimed at. Next slide, please. And we know that the more victims who seek and receive immigration relief, the more trust that police, prosecutors are able to build with the immigrant communities. And when there's trust, there's reporting, there's participation in prosecution, and there's overall increased safety, not only for those victims, but for the community at large. Next slide. So as you've seen and you will see, there are a large number of types of crimes that qualify. However, we know that close to half of the criminal activities that are included in U visa apps are domestic violence. And then a close second to that is sexual assault crimes. Next slide.
One more.
One more. Thank you. Okay, let's do another poll. Immigrants are uniquely affected by domestic and sexual violence because, is it A, the US Constitution does not protect them? B, offenders prey upon immigrant victims' fears and misconceptions, count on barriers to prevent the reporting of crime, and manipulate the legal system to assert power and control? C, resources to help victims are only available in English? Or lastly, state laws do not require police to help immigrant crime victims. So please click one of those boxes with your thoughts.
Or more, one or more. You have multiple choices.
So
Yes.
about 57% of the participants have put an answer in. So I'm just going to give it another second or two to see if we can get some more. Alrighty.
Okay. And you're right. B is the most true. And it's also true, of course, that resources to help victims are sometimes only available in English. It's really important that we in the system, whether you're with an advocacy organization or police or prosecution, that you are certain that the people that you serve understand the services that you can provide and how the system works, and that information is available to them in English. But that can be absolutely a barrier. Of course, the US Constitution protects all people who are here once they're here. And state laws generally don't exclude immigrants from the protections of police. Next slide.
Thanks, Tara. So, every time I see that slide that talks about the percentages, my brain starts spinning around the DV offenders and the work that we've been doing around the lethality of DV offenders. And we see almost half of U visas issued under that time period under the domestic violence criminal activity, and then add another 20-something%. You're like at 76% with domestic violence and sexual assault. So we're not talking about, people that are nuisance, criminals in our community. We're talking about some real violent offenders that are out there in the shadows. And we've heard so many stories. I've experienced things. We did a training outside this major city in the country, and we were in front of the room, big room, and in the back of the room was a guy that was like this old school detective guy out there with his arms crossed, like he was a prisoner in the room and didn't really want to be there. And even at the breaks, we were like, wow, this is something's going to happen at some point where he's going to come up with something to throw it at us. And towards the end of the training, and I'm making that kind of a long story short based on our time, but towards the end of the training, he stood up. And of course, like everybody was like, oh, what's this going to be now? And he told us his story about how he and his partner had infiltrated one of the most violent gangs in this country. And they had moved up the ranks, and they were working on taking down this gang, or at least a big part of it. And at the same time, the gang leader's girlfriend was working with the domestic violence sexual assault unit on a DV sexual assault case where this guy basically was abusing her. He was letting other gang members have their way with her, like really bad stuff going on. And because of the mere fact that she had built trust in the DV guys, sexual assault detectives, she told them, hey, they know about police officers. There's police officers that are in the gang, and they know about them, and they're going to take them out. They're going to kill them. So just that mere fact of working really well and having best practices in domestic violence investigations saved 2 officers' lives. And, we've been doing work around officers killed in the line of duty. Unfortunately, we're not done yet. I feel like we've been talking about it for like a decade now. But COVID kind of got in the way with some of the staff people we had doing it. But without being specific, on the stats, it's in the stuff I've been seeing, about 68, maybe closer to 70% of all officers killed in the line of duty in this country are killed by an individual with extensive domestic violence history. So when you look at their history, there's a percentage of them that have some other real violent crimes. There are those that have violent crimes and DV and restraining orders, but there's a large amount, a crazy amount that have, no other real violent crimes on their record, but they have domestic violence, and they're killing police officers, not just responding to domestics. They're killing police officers sitting in their cruiser watching traffic, responding to check the well-beings, traffic stops. So my soapbox is, of course, that we need to do these things, and we need to, these offenders, these DV and sexual assault offenders are preying on these undocumented victims in our community. They're in the shadows, and this relief that we're about to talk about will take those violent offenders out of the shadows, get our eyes on them, and protect our community, protect the victims and the households that they're terrorizing, and also protect us in law enforcement as we're out there doing our duties too. So I'm going to get off my soapbox, though, because I'll just keep
No,
going.
but I also think one thing that's really important there is that the officer, basically the officer that the victim went to was the U visa certifying officer for the case. So she was an immigrant, and she went to the certifier to save the lives of the 2 undercover agents.
Yeah.
Tara, were you going to say something?
No, I was just commenting that we just had an officer shot in the line of duty on a domestic just 2 days ago in St. Paul. And I'm echoing what Mike's saying about the dangerousness of these perpetrators on DV. And that guy had no record whatsoever. So this is what we see.
Yeah. So we're going to now turn, if you can go to the next slide, to some of these domestic violence dynamics. And I'm going to show you a video that was created by the Department of Homeland Security to train its own officers about domestic violence and immigration. So let me see if I can share my screen and make this work. Keep our fingers crossed. Do you see my share? Oh, wait, everything's optimized. Yep. And here we go. Let's see if it works.
Michael, good to see you. How are you? How's Julie?
Oh, Julie's fine. You know Julie. Look, Gloria, I got your mail again, so.
I am so sorry this keeps happening to you.
Oh, no, it's not a problem. Seriously, I get to come by and see you, so.
Thank you.
Absolutely. Well, there you go. We'll see you later then.
Okay, Michael, see you. And say hello to Julie for me.
I will. Thank you. Bye-bye.
Okay.
Having fun with your friend?
You frightened me. Michael brought me the mail.
Well, is he the only one? Are you sleeping with every man in the neighborhood?
I don't understand. I didn't do anything wrong.
Oh, no, you don't. I don't even know if that baby's mine. You know, I could have you deported in 2 seconds and take that baby from you. You speak to no one. Remember what happened the last time you upset me.
Sorry.
You better be sorry. This is my house, and I make the rules. And now I'm not going to file those papers for you. You see this?
No.
This makes you mine. You won't be going nowhere, not working without this.
No, stop.
Happy now? This is all your fault. Why do you make me do this?
Okay. Back to the slides. Mike, turn it over to you. Oh, we can't hear you.
You want me to do I'm sorry, you want me to do this slide?
No, I wanted you to do
You
the.
did debrief the video, right? Yeah. So what did we actually, the chat will help a lot with this. What did we see for those dynamics that were happening, the power and control things that this individual was utilizing against the victim in this video? And some of the stuff that already came up, but we need your help in the chat to move us along. He's definitely controlling her status, right? He said he's not going to file papers for anymore. He has access and control of her passport. Yes, threatening to have her deported, destroying her papers, definitely controlling her. A lot of the, I mean, and the thing is too, like
Using the child.
Yeah, the child. I was going to bring that up to the child. A lot of these dynamics we've learned about, and we've recognized in all of our DV responses and our DV training, but they're magnified. And there's others that come in when you have a person who's undocumented that's also a victim of domestic violence. And you see this with having her deported and having her separated from a child, taking the child away from her. He's in control of her papers. So with that control, she's going to do anything that he wants her to do. So she maybe has some light at the end of the tunnel to have him fill out the paperwork.
And so let's, next slide, please. As we think more about this, the coercive control using immigration status as a tactic, we see from national research, we're seeing that over 70% of the time, when one family member can control the immigration status of another, when a spouse a husband can control of a wife or vice versa, we're seeing 70% of the time they never file immigration papers. And even when they do, there's a mean delay of 4 years. When in a normal relationship, if I get married to somebody from another country, the first thing I'm going to, very early on, within months of the marriage, I'm going to file the immigration papers. It's highly unusual to have these waits. And we see this in 65% of the cases involving immigrant survivors. Next slide, please. And we also see there's all these kinds of things, like you saw, refusal to file the papers, withdrawing papers, destroying documents, forcing people to work under false documents, threats of deportation, calls to DHS. I mean, in the old days, when I did this work at IUTA, all my clients would tell me that their abusers were saying they were threatening to call them and turn them into DHS, but nothing ever happened. But what happened was, back then, nobody was sitting by the phone. As DHS, Department of Homeland Security enforcement, staffs up, now when abusers calls, there are people calling and responding to those calls. So as prosecutors and police, if you want to make sure that your victims stay around and are not don't just disappear into immigration detention, it's really one of the things you can do and is use the U visa as a tool. So, or connect the survivors, those of you that are victim advocates and victim witness in the law enforcement, connect them with local programs that can help them get their U visa or their VAWA self-petition filed. Because as soon as those cases are filed, it notifies USCIS, it notifies immigration enforcement as well as USCIS, that this is a victim and that this certifying official, the prosecutor, the police officer is working with this victim, and it gives them a heads up and a red flag, so that instead of responding and going after the victim at the perpetrator's behest, DHS offers that victim a victim-centered approach. So it's really key, timing matters about how quickly you identify people and get them started. Next slide, please. And this is the data. 25% of perpetrators are actively trying to report victims for removal, and 35% are very effective because of not having language access, because the victim isn't provided language access, in getting victims who call for help arrested. And I know I've seen cases in Maryland of this. So it's something to be very careful about, and why language access at crime scenes is so important. The other thing you should know is that U visa applicants and VAWA self-petitioners have much higher future crime reporting rates than other immigrants. So it does demonstrate how that trust is beginning to build. Next slide, please.
So let's do another poll. What do you think prevents immigrant victims from reporting crime and/or participating in investigations and prosecutions? What do you think is getting in the way? Fear, broadly fear, right?
And
Fear of the perpetrator. Fear of immigration consequences, communication barriers, lack of knowledge of the legal system. So all these are true. Fear of deportation. Yep. Mistrust of police. It's another good one. These are great, you guys. Communication barriers. That's right. Those are all good. Next slide. So let's dive into those a little bit. Victims fear all of the things that you've talked about, deportation. They fear going back to depending on what the situation is in their home country, they may fear going back to their home country, which can mean being separated from their children, being separated from their community, being ostracized from the community, or retaliated against either by the perpetrator or even people in their community. Next slide. Many victims believe that they have, because they are undocumented, they don't have any legal rights as a crime victim. They may not know that that domestic violence and sexual assault is illegal in the United States. They may fear that anyone wearing a badge essentially is someone who is there to arrest them. So there's a really strong distrust often of police. Sometimes people come from a country where police are very corrupt. And so there's a belief that if they call the police, they may be in more danger than they would be if they just put up with what's happening to them. And then this overall sense that not only do they not perhaps understand the criminal justice system and how it works in the United States, but this feeling that the criminal justice system simply won't do anything to help them because of their status of being undocumented. Next slide. So some of the barriers to safety and justice that victims may experience can include, of course, the language barriers. You identified that earlier. Not only may they think that the police won't understand them, but they are also afraid that I won't understand the police when they come. Financial dependence on the perpetrator. Isolation is a big one. Lack of transportation. It could be lack of transportation to go and report a crime, to participate in the case, whether it's ongoing investigation or the prosecutor's office. Lack of transportation to seek safety, to seek shelter, those kinds of things. We have community and family pressure are big in St. Paul. We have a really large Hmong population, and in that community, the domestic violence is something that is absolutely supposed to have to be dealt with in the home and among the elders. And so there's this feeling that I just simply can't go outside of that. And there's a lot of pressure from their perpetrator and from the elders in the community to not participate in prosecution, not give any information to police. And so while a victim may have called police out of pure need when they were in danger, that pressure to not give anything more, not participate further is really, really strong. And then, of course, religious factors weigh into that as well. Next slide. So generally, knowledge of U and T visas are going to lessen all of these things we've talked about. They're going to lessen the misconceptions that victims have. They're going to lessen the fears, and they're going to break down some of those barriers that exist, and ultimately lead to more victims calling for help, more victims being confident and secure in participating in not only an investigation, but perhaps even later on in a prosecution. Next slide. Oh, sorry.
Animated. There's your immigration relief reduces the fears. And next slide or next. And victim participation goes up. Sorry, it was one of those animated ones.
You.
Now next.
Now next slide. Okay. Another poll. How do law enforcement, prosecutors, and government agencies benefit from the U visa? And a lot of us are on this call. How are we benefiting from victims applying for and getting a U visa? Thoughts?
seeing trust from the victim, participation, investigations from victims.
Yeah, that's the big one, trust and cooperation. And I think along with trust goes security, assistance with charging the defendant. Yep, that happens because they're reporting and they're giving enough information that we as prosecutors may have enough to charge out a criminal case. And perhaps even at that point, not need further victim participation if we're able to practice evidence-based prosecution. All right, those are all good. Next slide. So yeah, let's talk about some of the benefits for both law enforcement and prosecution. I think a couple of these that I don't need to read all of these, but a few that I want to highlight is really just showing our commitment to protecting immigrant community members. That sends such a strong message to individual victims and also your community that you're someone who cares about victim safety first and foremost, even more than we care about the outcomes sometimes on our prosecution. Our first concern is victim safety. Another one I want to highlight is reducing repeat calls and recanting victims. Again, if victims are trusting the system, if they feel confident and secure and able to participate, they're less likely to be recanting a previous report that they made to police. And then overall, we're enhancing both officer safety, we're enhancing individual victim safety, and we're enhancing the safety of the community at large because we're bringing a lot of these dangerous offenders out of the shadows. Next slide.
Yes, and in 2018, the IACP, International Association of Chiefs of Police, they put together a resolution and voted that in that recognizes U&T visas as significant crime fighting tools and using these U visas and T visas as a best practice when crime fighting. Supports training, education, communication, increased police leadership involvement, and also commits to the increasing collaboration, and that collaboration is absolutely needed when we work in these cases and utilizing this relief when we're all working together. And then just a small little quote from out of there in that resolution. It says U visas are effective tools for law enforcement agencies that enhance public safety, officer safety, and protection of victims nationwide. So we were really excited when that happened, when you have a national organization like the International Association of Chiefs of Police that puts together a resolution like that. And then shortly after that, the National Sheriff's Association did the same. So that's just something that we can utilize, and those are organizations that we can lean into to assist us with doing our protocols, our policies, putting our plans together.
Great. Next slide, please. So taking it to Maryland, next slide, is that basically Maryland, like following against this history that we're talking about and the benefits and what the role of the International Association of Police say, their encouragement that everybody should be certifying. Maryland has a statute that requires all of the following listed agencies to be signing U visa certifications: state and local police, prosecutors, child protective services, the Maryland Commission on Civil Rights, the Maryland Department of Labor, and any other agencies responsible for detection, investigation, prosecution of cases involving U visa criminal activities. So another one that would fall into that last bucket that jumps out at me would be Adult Protective Services in Maryland. Next slide, please. And the Maryland law, as do many state laws, require that a decision on the certification happen within 90 days of the request and 14 days when the victim is in removal proceedings. And that when law enforcement or prosecution agencies fill out, or any of the certifying agencies fill out a certification, they have to include by statute the details of the criminal activity, a description of the victim's helpfulness, and provide copies of police reports or photographs or other kinds of things that might be useful to the victim to prove substantial harm. And what's really important is the law confirms and clarifies that a current investigation, filing of charges, a prosecution, or a conviction is not required for the victim to get a certification. Next slide, please. And that the statute also defines helpfulness as once somebody has come forward and assisted in the detection or investigation or prosecution. So filed a police report, called 911, spoke to officers, we'll talk about all the different ways that can happen, then they shall be considered helpful for purposes of the U visa. So if they've come to you and done anything to help in the past, that's sufficient. And it's also important to note when you're talking about incapacitated, incompetent, or child victims, a parent, guardian, or next friend can provide that helpfulness. Next slide, please. And then lastly, under the Maryland law, and not least, like the federal law, there are confidentiality protections that go with this to prevent perpetrators from interfering in your case, in Michael, in Tara's case, in Michael's investigation, or the victim's immigration case. Next slide, please.
All right, let's dig into the U visa as a crime fighting tool. First slide that we have, the next slide, please, is just a little poll to find out how many U visa certifications have you been involved with. So fewer than 5, between 6 and 15, 16 to 25, more than 25, or maybe you're not sure because you're not involved in the certification process.
All right, we have about 50% that have responded, so I'm just gonna give it another few seconds. Alrighty.
All right, fewer than 5, 50%. And then we have a three-way tie, 6 and 15, more than 25, and unsure at 17%.
We have a good mix, which is great. I mean, it's not at all unusual in the trainings that we do nationally. That's why we do the trainings, to get everybody to understand how important a tool this is.
Definitely. Next slide, please. All right, so some basic things about the U visa. A law enforcement certification is just one part of the overall process. It doesn't give that person the visa or citizenship. There's a whole bunch of other steps that have to happen once us as certifying officials, we sign that certification. It's meant to promote the reporting of a crime. Like we said, we're trying to bring these survivors, victims out of the shadows, which in turn is going to bring those violent offenders out of the shadows in our community. We're targeting those dangerous offenders that prey on the most vulnerable in our community. The offender could be a citizen or a non-citizen. It can be revoked. So if you do sign a certification and then further on in the process, you determine that the person that you signed the certification for was being unreasonable in their failure to cooperate, if you will, or be helpful, you can call the special phone number, special line that's there for us that you can call and revoke that certification. We'll get a little more detail into that and where that really would end up. I think once we have the conversation, you'll find that there probably isn't a whole lot of times where their failure to cooperate is going to be unreasonable based on the crimes that we're talking about. And then it increases immigrant victim participation in the criminal justice system. And Leslie, I know you've done a lot of work around just that bullet point where the work that you've done has showed that there is more participation and continued participation within the case and the system when this relief is a part of the process, right?
Right. So what we see is that when you visa certificate, once a victim gets a certification and their case progresses, they file their case, and by the time they get work authorization in that case, we see 114% increase in willingness to trust the police. We see a 60% increase in their willingness to come to court, and not only in the criminal case, but they start doing protection orders and divorce and custody and start really turning to the court system. And really exciting is that 22% reach out in their communities and help other victims come forward and report. So it really does help in a broad range. And one other thing while we're on this slide, we call this law enforcement certification because that's the term DHS use. It's not just law enforcement. It's that whole list of certifiers. It's a government agency certification which would be a more correct term. So people sometimes get confused by the term law enforcement. I just wanted to correct it.
Thanks.
And I'll add also, I'll add also to that we have seen in our community, we have several examples of situations where victims have gotten a U visa and then subsequently reported other crimes unrelated to the crime for which they had initially applied. We had a case not too long ago where someone reported a gun-related crime or firearm-related crime, and we were able to successfully prosecute someone for a firearm-related offense and get a bunch of guns out of the hands of people who shouldn't have them. So there's just so many benefits to the community.
Yeah, that happens a lot. We've had cases where we've uncovered multiple victims as a result of just one victim coming forward and going through the process and building that trust. And Leslie, those statistics are just amazing. I mean, it really shows how important it is to get this relief out there in our communities, to get policies in place. And we're going to go through what a qualifying criminal activity is and how you actually, become able to request this relief or be a person that can obtain this relief. And you're going to see that the Maryland law is pretty close mirrored to the language that the law that we're going to talk about. So if we can go to the next slide, I'll start to get into that a little bit.
We're going to pick up some speed too, Mike.
Okay.
Next slide, please.
So U-Visa requirements, the victim has to be a victim of a qualifying criminal activity. They have to have information about that crime. The criminal activity has to occur in the U.S. or violate a U.S. law and admissible to U.S. or granted waiver. Helpfulness, and this is just like the language in your law. They have been, are being, or are likely to be helpful in the detection, investigation, prosecution, conviction, or sentencing of that criminal activity, that crime. It's an R, it's not N. That's really important, which means a person can call 911, help. We go there, we respond. They say, yeah, my boyfriend did this to me. They let us take a photograph, let's just say. And then the next day, me as an investigator, I go to do a fault investigation. They slam the door in my face. They don't want to cooperate with Tara. We still can sign that certification. We have to determine whether or not that person's, not wanting to participate or be cooperative with us is reasonable or unreasonable. And the crimes we're talking about, and we're going to see the list in just a second, you'll see there's a lot of really good reasons why they might not want to come forward. And then the harm part of it is that the victim has to have suffered substantial physical or mental harm as a result of having been a victim of that criminal activity. That's not something that we need to have that box checked to sign the certification, but we play a very important role. We may have medical records, photographs of injuries, that type of stuff. But if we can't determine whether or not they have, we can still sign that. USCIS will do their job and they'll get the paperwork that they need to check that box. Next slide. And here's the criminal activities. You can see the crimes here. I mean, some of the most violent, things that can be committed against another human being when you look at this list. And we already talked about the sexual assault, domestic violence being over 75% of the crimes that we're seeing U visas be issued under. And it does include also the attempt, conspiracy, or solicitation to commit any of these crimes or similar activities. So let's just say in Massachusetts, for a long time, big part of my career, we didn't have domestic violence as a charge. We had assault and battery, and then we would hand add the domestic violence tag to it. Now we do. So that assault and battery, being with a family or household member, is how we would change that. So anything that's kind of similar to that, the crimes, the elements of the crime are similar, that's totally fine.
Next slide.
Next slide.
So similar activities, there have been a couple of similar activities that DHS has formally recognized as deeming similar in most circumstances. So hate crimes, video voyeurism. They see elder abuse, abuse of adults with disabilities, and child abuse as falling within kind of similar crimes to domestic violence. And then robbery or aggravated robbery could be similar to felonious assault. Next slide, please.
And Lizzie, you already kind of alluded to the list of who can be certified, but I think we're going to see.
Next slide, please.
Next slide. We're going to see here. This is the list of who can certify. So it's law enforcement and law enforcement agencies. Leslie, you mentioned elder abuse, child protection services agencies. Obviously, all the people under the police umbrella, police, sheriffs, FBI, HIS, ATF, prosecutors. The person can either be the head of the agency or the head of that agency, the leader of that agency can now tell USCIS that I'm going to make this person, that person. They can assign people to be certifying officials. There's a couple of caveats where they have to be in a supervisory role and that type of stuff that you can see from some of the materials that we can provide through our library. And there's no statute of limitations to sign the certification. But once we sign it, that victim, through her attorneys, whoever's helping her out with that paperwork or him out with that paperwork, has 6 months to file that with USCIS. So if 6 months goes by and they didn't collect the documentation needed, they would have to come back to our agency and have a certification signed again, which is totally fine. We've done it numerous times. Next slide. So Leslie, why did Congress design the U visa to authorize multiple agencies to provide U visa certification, not just law enforcement or prosecutors?
Yeah. So, and I'm also going to answer the question about who determines who signs, because that was the issue. So when we were drafting this part of the U visa, there was a long discussion about this. And what Congress decided is that they wanted multiple entry points. They wanted to have as many doors to the justice system open as possible, because you could never know where the victim was going to build trust and who we're going to turn to. And we wanted police to continue to be able to certify after the case went to the prosecutor. We wanted prosecutors potentially be able to certify before the case came to the prosecutor. We wanted to have APS and CPS and have multiple options, have courts, judges be able to certify after they issued protection orders, because the idea was to get someone into the system as soon as possible after a professional whose day job it is to detect crimes, detected the crime and observed the victim's helpfulness. Because what we hoped would happen is we wanted people to come to the justice system, cooperate in criminal cases, and file police reports, and also use the civil side of the justice system to keep themselves and their children safe. And so that's why, and we knew there could be places where one agency would decide not to certify and they need to go to another. We didn't want that to happen. That's not supposed to be happening in Maryland. But the idea is a victim can go to either the police or the prosecutors or Child Protective Services or the Maryland Civil Rights Agency, whoever they've had contact with and has observed their helpfulness to get certifications. And the certifications also can happen. You might have a child in Maryland who was sexually assaulted while crossing the border, and the Texas Police Department wouldn't take the report. And they get here and they report it to a to the school and then to a police officer here. And because the person's here and it doesn't matter, they can make that police report whether or not the crime actually occurred here, and they can make the U visa certification either way. The idea was to open it up. And the reason people shouldn't be concerned about that is, next slide, please, is that there are multiple points in the process. So what happens is, as soon as somebody files for a U visa, part of the application process is they take fingerprints and they run those, and DHS has the discretion to deny or grant a U visa to somebody that may have some kind of criminal background. But the idea here is to encourage early certification by multiple certifying agencies, get people filed, and then DHS will take it from there and worry about, like, if in fact the person ends up being a really bad actor, they're going to deny their U visa because they're not going to exercise their discretion to grant them one. And they're going to go through what's now a 10 to 20-year process where their background checks are regularly occurring. So you don't have to worry if you make a mistake. There's a way to revoke, as Michael told you, but there's also DHS checking up on whether they really want to let this person into the country, ultimately. Next slide, please.
Next slide. So some basic facts: only 10,000 U visas are granted annually. Bona fide determination with work authorization occurs around 4 or 5 years after that filing. The U visa gives a temporary 4-year stay. Some of the U visa holders will qualify for lawful permanent residency. There's no guarantee that's going to happen. And then the next step in that would be, after lawful permanent residency for 5 years and proof of good moral character, they could apply for U.S. citizenship. Next slide.
And just good moral character, the primary thing that USCIS is looking at for good moral character is criminal record.
Yeah.
So again, it's like if you certify and this person turns into a bad actor, they're not going to make their way through the whole process. Next slide.
And then who can apply is our next slide. So any victim of the qualifying criminal activities that we talked about just a few slides ago. Parents and guardians can apply as indirect victims if the direct victim is a child under 21 years old and/or the direct victim is incompetent, incapacitated, or deceased due to murder or manslaughter. Indirect victims have to demonstrate they were or are being or likely to be helpful, just like direct victims. And when the victim's a child, the helpfulness requirement can be met by a next friend, quote unquote, or a family member being helpful. So bystander victimization does occur and it can apply, but it's very limited. Leslie, I don't know if you want to, do we
Yeah,
want
I'll
to go
give
over
you.
the example?
I
Is a
think-
good example.
Yeah. So this bystand, when the U visa regulations were being written, there was a case that had happened actually in Virginia that DHS was aware of when they were writing the regulations. And this is what they used as what they were thinking about as they tried to figure out who's a bystander and whether a bystander could ever be a victim. It was a domestic violence case. There'd been a split up between the parents of a child who was like, I think 4 or 5 years old. Summer, Virginia, they're having a party on the front lawn of the house for the birthday. And the abusive father, the father abused the mother, came by with a weapon and tried to kill the mother and shot other people at the birthday party. And one of the people who actually wasn't shot but was present was so terrified. She was pregnant and she miscarried as a result of being there during the shooting. So that's an example. So for a bystander to qualify, they have to show substantial harm as a result of the criminal activity. And so the miscarriage at the shooting at the birthday party is the way to think about it, kind of how this happens. It's not common, but it's not impossible, depending on the facts of the case. Next slide, please.
Okay, Mike, on a previous slide, Mike talked about the definition of helpfulness being any of these things that the applicant has been, is likely to be, those are ors, helpful in the detection or investigation or prosecution or conviction or sentencing. And it's really important that you understand how broad that is, and that even if a person is unhelpful in everything other than the detection of the crime or in everything other than the sentencing, unless, and we're going to talk about this in a few slides, unless based on what you know that unhelpfulness was unreasonable, and that your request was reasonable, they can be considered helpful for purposes of their U visa certification. So it's really a broad application. Next slide, please. And you as the certifier are the one determining helpfulness. And I encourage you, again, think broadly. Think of this based not only on the the totality of the circumstances, on what you know in that fact pattern or in that relationship, or history of violence in that relationship. Think of it not only in terms of that, but apply what you know about the dynamics of not only domestic violence, but the dynamics of immigration abuse, and apply that when you're deciding whether someone is being helpful in any section of this case. Keep in mind that their criminal history doesn't preclude them from U visa eligibility, and you don't need to go in when you're asked to certify. There's no need for you to go in and run a criminal history check or figure out those things. That's not your role. Your only role is determining helpfulness. And as we've already said, that certification can be revoked. Next slide. So these are some examples. When we say think broadly about helpfulness, these are some examples. Can you think of any other examples that might apply? So calling 911. Now, sometimes a neighbor calls 911, right? So 911 is an easy one, but what if a neighbor calls 911 and there's a rape that's occurred and the victim goes and submits to a SANE exam and then disappears and we never see her again? Can we still determine that that person's helpful? Yes, you can. Filing an order for protection, even though that has nothing to do with your criminal case, that may be something that you can determine that is helpful to the ultimate detection or prosecution or investigation of a crime. Bringing someone to court, bringing a minor to court. These are all things. Another one that's not on here would be participating in a sentencing, giving a victim impact statement, even if that person has never participated in any part of the prosecution, but shows up at sentencing and gives an impact statement. That can be considered helpful. So again, this is very broad. Next slide.
You know, Tara, I think about like all the crimes that we investigate and that you prosecute, all these violent crimes. How many of them do we actually have victims or witnesses that cooperate through the entire process and get up in the stand and then like pointing the fingers at the defendant? When you're talking, especially domestic violence, sexual assault, some of the other real violent crimes on the list. So it shouldn't change the survivor dynamics conversation or thought process we have when they are reluctant to cooperate and go forward. It's probably for a lot of really good reasons. And as long as we understand that, we won't get hung up on, oh, maybe I shouldn't sign this.
That's absolutely true. And we know that the dynamics of violence are even more intense often when immigration issues are present. And so I think that can be even more true in those cases. So this is a list of things that aren't required in order to certify that a victim has been helpful. We really want to think about helpfulness from a very victim-centered lens. Know that none of these things need to be true in order for you to consider a victim to have been helpful. In many cases, you may have a situation where a victim called 911 or a victim gave a report at police, but you just at the scene, but you just don't have enough information or you don't have sufficient evidence to charge that case. You can still sign a certification in that instance, even if they report a crime and they don't even know who the offender is, or they don't report who the offender is. That's still helpful. All of these things are not required in order to certify that a victim has been helpful. And of course, testimony at trial is another thing that's not required in order for you to consider a victim helpful. It also doesn't matter if the case that you have is currently open or is going to be open or has been closed. I've been our certifier in my office for many, many years. And we often get cases that have been long closed. Maybe they were dismissed years ago, but I can still look at that and make a determination. So really just be thinking of this in terms of a victim-centered approach. Next slide. So, and I mentioned victim-centered, of course, I'm sure everyone on this call is familiar with the concept of being victim-centered, but in this context, DHS is really encouraging that we equally value identifying and stabilizing crime victims to prosecuting those offenders. So we're not wanting to push forward with a case at the expense of victim safety and stability. In our prosecutions, it really largely whether immigration is an issue or not, in our office, we are really centered on first victim safety and then prosecution. And the beauty of that is when you stay victim centered, the more successful prosecutions follow. Next slide.
Mike, you're on mute.
Can we go to the next slide? We'll just real quick, just list here how the certifications will come to you. So you can get those through a victim advocate or immigration attorney. As a police officer, you're the first responder on the scene, that you're going to have that request come there possibly. Or as a prosecutor, you might have continued contact with the victim and might be first to identify that eligibility as being, someone who's eligible for the U visa. And if you guys have had any U visas come to you from different ways, different avenues, please, type them in the chat box and we'll bring those out. Next slide.
Great. So just going to quickly mention, there's also relief for human trafficking victims. And I think it's important to understand, I just put in the chat a series of webinars that we did with the Office of Trafficking in Persons at HHS, and it has lots of materials on trafficking. The reason I'm raising it here, next slide, is that it is a U visa criminal activity, and it also can qualify for a T visa. And Maryland is one of the states where, if you identify particularly a child who's been a victim of sex or labor trafficking before they turn age 18, that child can qualify for, and we will email the slides. That child can qualify for an Office of Trafficking in Persons letter from HHS that gives them access to federally funded public benefits for life. So more access to healthcare than is available even in Montgomery and Prince George's counties, which have the highest level of access to healthcare for immigrants in the state of Maryland. So it's important to be able to identify when trafficking is happening within your domestic violence, child abuse, sexual assault cases, and independent of them. This is the federal definition of human trafficking that requires force, fraud, or coercion for sex trafficking. Anytime you have a child somebody who's over the age of 18, I'm not going to go into a lot of detail because we're short on time. Next slide, please. This is the definition of labor trafficking, which includes a process of recruiting, harboring, or obtaining essentially labor. There's always through use of force, fraud, or coercion. There is no force, fraud, or coercion exception for minors under the federal statute. And the purposes is involuntary servitude, peonage, debt bondage, or slavery. And involuntary servitude is what you see commonly in family relationships. Like the battered spouse was forced to work for the husband's family's business and not paid, is kind of the way to think about it. Tara?
Oh, I just want to add, we see this in domestic cases, a fair amount. And I think if folks can be thinking broadly, that if a victim who's applying for a U visa also might qualify for under labor trafficking, to go under that, because the wait list, as I understand, is significantly lower than U visa.
Right. The U visa, by the time you get your visa, could be 20 years. T visa, by the time you get your visa, is 18 months. Or by the time you get work authorization and you're close to getting your visa. It's a big, big difference. And if it's a child labor trafficking or sex trafficking victim, we're talking about a less than 2-month wait to a letter from HHS. It's really fast. And that HHS letter gives the child trafficking victim access to benefits, a federal caseworker that provides them social services, all kinds, and social work support. So it's really, really important. Next slide, please. The definition of the T visa eligibility is this: you have to you have to qualify for a severe form of human trafficking, which I just showed you, and you have to meet these other qualifications. There's also, next slide, something called continued presence that I'll turn over to Mike to explain.
Yeah, so I think, for us in the local law enforcement prosecution umbrella, we need to understand and recognize who the federal authorities are that we need to contact. So you need to identify HSI folks in your area, FBI, the federal folks, because when continued presence comes into play, we have to request that. We have to go to the feds and ask for the continued presence to be issued. So it's basically a temporary immigration status for any victim of human trafficking who may be a potential witness in sex and labor trafficking. Victim and certain family remain lawfully in the U.S. during the investigation or prosecution of human trafficking. So it's basically giving them that ability to stay in the U.S. while this is going on. It's granted for 2 years. It can be renewed if the case goes longer. They receive work authorization, public benefits and services, and judges as well, because it happens a lot when these cases are going on. Judges can refer victims to federal authorities as well. And those authorities are the ones I mentioned, the ones that are authorized to file continued presence applications through DHS. I don't know if you want to add to that.
No, that's good. We're on. Next slide, please.
So when should you certify? Next slide, just kind of show a little map here. When you're analyzing any kind of request for certification, you're looking at that list that we went over. What kind of criminal activity are we dealing with? Do we have victims or indirect victims? Determine the helpfulness of that individual, which I think that Tara did a great job of showing how that can happen easily. Like, we're not talking about somebody that's going through the whole process necessarily. We identify if any family members were implicated in the crime, and then note any injuries observed, provide documentation, any of the things that might help USCIS in making the determination. Next slide. So next slide, please. Yep. So this is a hard slide to read. Don't worry, I can't read it either. But this is basically the roadmap to a U visa certification request and the process it goes through all the way to the point where that relief gets issued. But you see that little blue square there. And if we go to the next slide, that blue square will pop up and we'll be able to read it then. That's our role Next slide, please.
Next slide, please.
This is the blue square that you see in that big map. So certification provides victims with, we have to sign the certification. It says here in blue ink, but I think that, you can sign
It
it
could be
in crayon.
crayon. It
Yeah,
shouldn't be black
they
ink.
actually told us that. And it is usually black. We use black in law enforcement pens, right? The head of the certifying agency, I mentioned that already. So they have to be the one certifying, or their designee. So that's a person in a supervisory role that they designated to be the certifying official for that agency. It's not necessarily one person. A small department in rural USA, it could be just one person or the head of the agency. But when you go to Boston, New York City, even my agency in Salem, we had 78 offices. We had different people. If you were in the gang and the human trafficking unit, we had people that were determined to be the certifying officials. In my office, I was anything that was domestic violence, sexual assault, the crimes that we handled. I was the one that was doing that. We want to make sure that we provide any support and documentation. So that can be any kind of statements, any kind of medical runs, EMT paramedic runs, photographs, obviously. And then if you are a designee and not like the chief of police or the major in the state police, there's a form, and we have that available in our toolkit. There's a form that that chief of police or sheriff or whoever that leader of that agency might be, the district attorney, can sign off and say, yes, Michael Riviere is a certifying official for the Salem Police Department. Pretty simple, actually. It's not a whole lot once you learn about it. Next slide.
Yeah. And so Tara, why couldn't a prosecutor, shouldn't a prosecutor wait until the case is over to sign a certification?
Well, Leslie, the main reason is we don't want the victims in our cases disappearing, either disappearing due to deportation or disappearing because they don't trust that continued participation in your case is going to compromise their safety, or the fact that they're or end up in their deportation or removal. So it's really important that you do that sooner. A lot of prosecutors that I've talked to throughout the years, one is think, oh, I want to wait until it's a little cleaner. I'm just going to wait until the case is over. The problem with doing that is that we know that the farther the victim gets along in their U visa process, all of the data shows the more likely they are to be continuing to and willing to participate in our case. The other thing is that once you've been asked, you've already created, you now have a situation that you have to disclose. The fact that they've asked you to certify is something that you have to disclose. So by just signing that certification, building trust, and then dealing with the fact that you have this, we'll call it an elephant in the room, is something we're going to talk about that in a few slides.
Yeah, we're going to get there really quickly. So she has lots of time to talk to you about getting rid of that elephant in the room. Next slide, please. I talked about this a little bit earlier, but this is the law that basically this is as soon as a U visa U visa request is filed by the victim, a U visa application or a VAWA self-petition, that case is red flagged to notify enforcement officials so that they don't go after victims. Next slide, please. And the process, the way it starts is right now, when they file, there'll be the first thing that will happen in their case after they check background checks and all of that will be that they get work authorization. That's running at about 5 years now. We're expecting. I just had a conversation with the Department of Homeland Security staff about this a couple of days ago. They're expecting, they just added 330 adjudicators to the unit. And they're expecting that number, that wait time will drop to hopefully under 3 years soon, in the next year or so. So basically they will screen the case to make sure that they think it's bona fide and will give work authorization. Next slide, please. These next 2 slides actually are the data I already presented to you. And so with the citations, and I can provide you more information if any of you want on the social science research that shows what Tara just said, which is how much more cooperative people become over time when they have a U visa case pending and a VAWA self-petition pending. Next slide, please. And the next slide. Yeah, I present all of this. Keep going. One more. There we go. Tara.
Okay, and we had this screen up earlier, but let's go into certifying early and the benefits of certifying early. The main point is the benefits far exceed any of the very scintilla risk that exists in the case. Sending a message to the victim that I care about your safety and stability is really the most important thing, and will build your case in a way that not signing really is going to, often that really gets in the way more than helping. Next slide.
So, Mike?
Yep, here I am. So raise your hand if you've ever had a case where the victim became uncooperative at any point. And I kind of alluded to this a little bit earlier. I think
So we're seeing a
we're
whole
all
bunch
being
of hands going up. I see.
Yeah, if we're being truthful, we've all had cases where the victim became uncooperative at some point. Next slide. So some of the reasons for refusing to cooperate: their fear, the continued threats of violence, the pressure from family, friends, others, financial reasons. It's a lesser of the two evils, where I'm going to be, going through all this separation of family and all that stuff versus putting up with what's going on in the household. And I think we learn a lot of this stuff over the years in our domestic violence, sexual assault trainings. Next slide. It's really what I mentioned earlier, where how it's magnified, and there's just some additional things when you're undocumented. Next slide.
Yes. What I put this slide up because, and the next two slides, what we're going to talk about is, so what you need for certification is the helpfulness we've been talking about in the either, has been or is likely to be helpful, has been or is being helpful. So you're not often, as a police officer or prosecutor, going to be predicting future helpfulness, because you've already got to get to you've already got actual helpfulness, either past or present. And then it's, as Tara said, it's all of these ors: detection or investigation or a prosecution or a conviction or sentencing. Then what happens is, once the victim files a U visa, the victim has an ongoing obligation to cooperate. And there's one exception. And that's what Michael was referring to earlier. And that is, the exception is they can show that their refusal to cooperate was not unreasonable, because they were afraid, because the perpetrator was holding them hostage. There's a whole variety of ways that can come up. Next slide, please. And so what happens is when they're trying to decide about this reasonableness, and this is, again, post-filing requirement for ongoing cooperation, first thing they're going to do is look at whether the request was reasonable. Was the prosecutor or the law enforcement official reasonable in making the request of that particular victim in this case? And then they'll separately look about whether the victim's refusal was unreasonable. Next slide, please.
So what's an unreasonable request? And as you think about this, consider, would participation in the investigation or the prosecution endanger the victim in any way, or the victim's family in any way? And if the answer to that is yes, then asking her to participate in prosecution or an investigation may be unreasonable. Next slide. So when you think about reasonable refusals, this is another, both of these things are very subjective. But again, consider broadly, consider if it's reasonable to refuse a request if the victim's in danger, if they're being manipulated or intimidated, if the victim isn't even aware of your request. Let's say you send a subpoena out, or you send a letter to them asking for them to call you, and they don't respond. And if you don't know that they ever got, then certainly you can't, then it's not unreasonable that she's not coming in per your letter. Being intimidated, threatened, all of these things would make a refusal reasonable. So you're looking at both the question of asking someone to participate, and is that reasonable? And then their subsequent refusal to participate. And refusal's strong, but that's the language that's in there. And applying a reasonableness standard to both of those things in a very subjective way. Next slide.
So this just talks about evaluating unreasonableness. The regulations require affirmative evidence and consideration of the things we've talked about: the totality of the circumstances, the nature of the victimization, the guidelines for the victim witness assistance, the victim's fear of the abuser, of the perpetrator of the crime, the trauma suffered, and that's both medical, mental, and physical, force, fraud, coercion, age, maturity, capacity of the applicant. So you can see there's a lot of avenues where you could determine that a person's failure to be helpful or cooperate in our investigation or prosecution may not be unreasonable. And the next slide will kind of go into that just a little bit more, and we'll move
I think
on.
it's actually a repeat. It might be a duplicate, kind of.
Yeah, it is kind of, yeah. So basically what we said, we can go forward on that. Go to the next slide.
All right, always consider that witness tampering is happening. We know, and the data suggests that in domestic violence and sexual assault cases, intimidation is near universal. So how do we know if a victim is being intimidated or manipulated? Well, we need to look for it. We need to train system advocates and our community advocacy partners in talking to victims about what that looks like. Working with, looking at jail calls, really investigating for witness tampering when you have a victim who was participating and then all of a sudden they've dropped off, that's a real red flag, right? So following up with anyone who may know what might be going on with that in that victim's life can be helpful and can either get us to a situation where we just know tampering is going on, and that may drive both our theory of the case and how we go forward, but also could be the basis for criminal charges. Sometimes the standard for that is really high, but still witness tampering, knowing about it, even if it's not criminally chargeable, is really important in our cases. Next slide. So when it comes to sort of recognizing that, just a few things. As I said, look for witness intimidation if you suspect it. We know jail calls are just a gold mine of all kinds of information. We could have a whole hour on just talking about jail calls and what to do with them. But another thing that we've found really effective in our practice is that we talk with victims. Our victim witness team is talking with victims at the beginning of the investigation, and the beginning of the prosecution, and letting them know the kinds of messagings that they may be getting from perpetrators or from other people in the community, and that may be wrong, that information that they might be getting wrong, and anything that we can do to sort of counter some of those messages, and also letting victims know that even if the things that you're hearing from your abuser aren't things that you think are probably criminal, they're likely things that we want to know about. And so it's important we have them letting us know, constantly giving us that information, so we can help counter. And then if we know those things, we can help victims safety plan around that. So we're going to skip a couple here and go right into some prosecution strategies, so we have some time to get into this. We spent a lot of time talking about the many benefits of the U visas, but as prosecutors, of course, yes, all these pros are all true, but we have to talk about the elephant in the room. We have to think about it, and we have to consider the arguments the defense might want to make a victim's immigration status or their U visa application applicable in our cases. Next slide. But really, with relatively minimal effort, often we can turn this challenge into a strength in our case. Next slide. So next slide. Oh, I'm sorry, back. I didn't see back. When the victim in your case is undocumented, you need to analyze your evidence and develop a theory about first of all, whether her immigration status is relevant. If it is relevant, think about the perpetrator tactics and the powerful dynamics that might have been occurring or still are occurring in your case. Is your theory that the perpetrator chose this victim because of their vulnerability? That may be one. Is your theory that they're preventing them from coming in, or intimidating them from coming in because they think that they're going to be deported? There's all kinds of dynamics that may be at place, and it's important that you kind of analyze how that fits into your theory of the case. Next slide. Often, evidence of a person's undocumented status or their U visa application can be excluded. It's irrelevant. There's case law supporting the fact that the probative value is substantially outweighed by the very highly prejudicial effect that it has. Most often, the victim's knowledge of a U visa came after they reported what happened to them, after they reported the crime. And that's a really important part of this conversation. It's important for you to be proactive and keep this information out because of how prejudicial it is. Often what I've seen is that defense attorneys, they just want the jury to hear that this person is undocumented. And that jury, then they're hoping, is going to make a judgment about that person and about whether they should believe that person, just about whether that's a person that they should care about. And so getting that information in can really be harmful. Next slide. And case law really supports this. This case, People versus Alvarez, is a California case from 2014, and it was a sexual assault case where the defendant wanted to cross-examine the victim on her application for a U visa, and the trial court said no, it's had no probative value. And really just sent the message that immigration status should not be the focus of your case. And I think this is a great quote. The visa in this case was tangential, collateral issue, and allowing evidence about it invited speculation about the legal status of both the victim and potentially the defendant, which was completely irrelevant to the case. So that's good language there. Next slide, please. This is a case from Minnesota that I'm making sure I also found a Maryland case, so I want to make sure I mention that. But this is a Minnesota case. We had a CSC in a criminal sexual conduct involving a child victim. And before the trial in this case, the defense gave notice of its intent to rely on the bias defense, saying that the child and her mom had known about, they did have some evidence that they knew about the U visa option before the abuse was reported. And in that case, then before trial, the defense made an offer of proof, which you should always request as you're going along in these pretrial motions. And if a judge is considering letting it in, getting an offer of proof is a really good way to kind of parse out these issues. During the offer of proof, it was clear that the witness knew about the U visa. However, a year had passed and they hadn't applied, they hadn't done anything towards getting a U visa. And the court weighed the probative value versus the prejudicial effect and excluded it. There are many, many cases of similar court analysis. Next slide. It's important that you educate the fact finder on both the dynamics of immigration abuse and the role of U visas. We're doing that. We do that with domestic violence and sexual assault cases. We have ways we can educate the jury during our voir dire process. And you're going to want to do that about the dynamics of immigration abuse. And if you know that the U visa is coming in, you're going to want to be doing some of that education during voir dire as well. Bringing in an expert witness. Sometimes defense will want to do that. We'll talk about that in a minute. But you may want to bring in an expert witness if you know that a U visa is going to be coming into evidence to talk about what those mean and why those laws exist. There's a whole lot of really good information you can get before the jury by calling an expert. And then, of course, through direct testimony. Next slide. So do we have to disclose information about U visas to the defense? I think, of course, as with any evidence, we're looking at, is it something that is within the state's control? And does it go to the witness's credibility, bias, or motive to lie? If we know that a victim has applied for a U visa, whether they've asked us or they've asked law enforcement, or even a judge, of course, can sign a U visa, then yes, I think that very likely that triggers our Brady obligation to go ahead and disclose it. Next slide. But
Can
you
I
have to
jump in, Tara? One important thing is this is where a VAWA self-petition and a U visa are very different, because the U visa has a law enforcement officer or a prosecutor or somebody from the government involved in this certification process, the cert itself is discoverable. On the other hand, in a VAWA self-petitioning case or a special immigrant juvenile status case, that child abuse or domestic violence case, there'll be no government involvement. It's not going to be part of your case, Tara. It's not going to be part of Mike's investigation. So none of that is discoverable, even in a criminal case.
That's a really good point. Thank you for making that. Yes, of course, we only have to disclose evidence that's within the state's possession or control. And if law enforcement has it, that's considered within our possession or control. But which items are really within our possession and control? If we are asked to certify, then that I-19B form is, of course, that form itself is discoverable. Communications perhaps that we've had, discoverable communications that we've had with the immigration attorney or advocate. Now, of course, an advocate's going to mostly have confidentiality attached, so that's not going to be discoverable. But and any accompanying documentation that accompanies the certification form that they send to us. It's really important that we are working, if you work in any kind of multidisciplinary team or work in your community, that you're educating the immigration attorneys in your community not to send you anything more than the certification form itself. We have everything that we need in our office in order to determine helpfulness. Between us and the police department, we have everything we need. And so the last thing you want is for them to send you more than you need, because then they need to know that that's going to be discoverable. Next slide. So the I-19B form is only really one part of the larger U visa application. So as I said, you shouldn't be getting the whole application. And you certainly won't get the whole immigration file. That's absolutely something that's not going to be within your custody and control. That doesn't mean the defense won't sometimes ask for it. When they do, next slide. It's really important that you're responding to, often that you're first forcing them to do a motion to compel, that you're not disclosing any information. You don't have the information to disclose anyway. You may be getting a motion to compel, and we definitely want to file motions to quash those. Keep in mind that it coincides with the existence of the certification itself. But that's all that we have. And the immigration file itself has confidentiality protections under both federal and state law. So that alone means that it's not discoverable. And you can also go down the hole of it's a fishing expedition, although I feel like we use that often enough that doesn't have as much power as throwing at them the confidentiality protections that they enjoy. Next slide, please. So, it bears out in case law. This the State v. Mariquin Aldana case is a CSC case, a criminal sexual conduct case out of Maine, where the defense tried to subpoena the victim's entire immigration file after he had already filed a certificate. After the defense attorney already had a copy of the I-19, the certification form. They wanted everything, and the court said no. The court said that noted the high level of protection, the confidentiality that that file has, and did not allow a disclosure of that. Next slide, please. So a couple of things here. First of all, it's really important to litigate these issues, the admissibility of immigration both undocumented status or immigration issues, and the request for a certification, to litigate those things pre-trial. We want to make sure that judges are getting an ample opportunity to review the law in this area and be thoughtful and consistent with case law in their rulings. Sometimes if judges do this on the fly, and the reality is they're not seeing a lot of these, and so they're not going to be as familiar with the law. And so it's really important that they're given proper time to analyze these issues. As I mentioned before, also when it's looking like the judge is going to include some of this information, getting an offer of proof and being very clear as to how far that defense attorney is going to be able to go is really important. Often the status is going to come in as, it may come in as motive to lie. However, it's really important that you watch for opportunities that this may create by opening the door to prior consistent statements. And we're going to talk about those next. Next slide. So when a judge has said, okay, you can ask, and there's a lot of case law where a judge has allowed someone to ask about a victim's undocumented status or ask them about their U visa application. And why? Because that suggests some bias or some motive to fabricate. When that happens, that means you have to look at a timeline, right? So actually, if we could just jump ahead a slide, I think it's helpful to just jump ahead a second. So what we want to do is we want to establish a timeline of when the victim made the statements of reported abuse, when that U visa, that application, or even an inquiry about an application came to you, and then their testimony. So if that motivation to lie came after the fact that victims made a statement to officers, then how can it be a motive to lie? So that's one way we can keep it out just simply as irrelevant. But if you could go back to the previous slide again. If they are allowed to go there, though, they open the door then to prior consistent statements. Now, thinking about prior consistent statements, this is all stuff you know, it's non-hearsay, so therefore, of course, it's not subject to Crawford. And it's any consistent statement that the victim has made about the abuse before the motive to lie came into play. So before that U visa application or inquiry or knowledge of the U visa came into place. And so with that, then you're able to ask, this can be statements to police, this can be statements to friends about the abuse, family, medical professionals, any place where she's made statements about the abuse that's consistent with what she's now testifying to in court. And you have a next slide, please. Actually, you can jump up a couple. We don't have a slide on this, but I was doing a little bit of research just right before we started, and there's a great case. Unfortunately, it's unpublished, although I note that the Maryland Supreme Court granted cert in November, just last month. It's Gonzalez versus State. You may be familiar with this already. I'll just give you the site so you have it. It's 2023 Westlaw 503170, and it's a case just from August of 2023. It was a DV case where there was a 2020 assault. A year later, the victim asked the prosecution to certify while the case was pending. The prosecutor did certify. The defense wanted to bring in that fact of certification to show that the victim now had a motive to lie. During the offer of proof, the defense cross-examined this victim exhaustively about this notion of a quid pro quo, that now you're going to testify so you can keep your U visa. But the court really pointed at this timeline. The court really leaned on this timeline and said that they held that there was no evidence of motive to lie on or before the date of the assault and the report of the assault, and therefore the cross-examination of her on the U visa would not be probative. So there was no showing of a quid pro quo. I'm sure you'll all be anxious to see where that case goes with your Supreme Court, but it's definitely one to watch. Next, People versus Sharp is another example of a situation where the court let in a cross-examine of a victim regarding her U visa status. However, they said, if we do that, if I let that in, then you are effectively opening the door to all other prior consistent statements this victim has made about the abuse. And that really then takes that dangerous information that you've been fighting so hard not to get in, and actually turns that into an opportunity to get a lot of past conduct in as relevant evidence. Next slide. Sometimes the defense may want to bring in an expert to talk about the U visa process. And, you know, the real reason in doing that, they're bringing in an expert to talk about it so they can get it out there and they can create this perception that there's this quid pro quo. You know, I would encourage you to, as I've mentioned, also consider bringing in an expert anytime where U visa is going to be admissible evidence in your case. And in this case, the language is here. I'll let you read this. You know that there's very good reason why the U visa program is in place, because without it, people like him can have free reign. They rape, pillage, and plunder a whole underclass of people in this country simply because they are illegal aliens. Different language, knowing full well that they, in their perpetual fear factor and their state of paranoia, are not going to go running to the police. That's really powerful language. It's probably a little inflammatory, but it was allowed.
And just a note that I want to make now, that the Department of Homeland Security has changed all of its publications, and they don't use the word alien at all anymore. They call everybody non-citizens. So just wanted you to know.
Yes. Okay, next slide, please. So going forward, I think it's really important that you're in front of this information. I think the main message we want to get across is certify early and often. Doing so sends a message to the victims that you care about their safety. It builds trust with not only your office, but with the prosecution, but with the police department. It will build a stronger case overall. And it also increases we know that DV and SA are pattern crimes. The likelihood that we're going to see this victim again, whether we have a successful prosecution or not, is strong. And so building that trust and keeping that trust is imperative. And then just be in front of this information and look at the case law in your state and know that we often can litigate around some of this harmful and really prejudicial information coming in.
Thank you so much, Tara. Okay. So what we're showing you right now, and we're gonna stop here for a second. No, go back one way, Rebecca. There we go. Just stop there for a minute. We have a U visa certification form here, and we also have in our materials a U visa certification toolkit that walks you through the form. We have a sample form. And so we're not going to go in today to the details about how to fill out the actual certification form, but we have materials available to you. And Tara and Michael and our team of law enforcement and prosecutors nationally, and myself and my office and staff can provide you technical assistance. If you have a question and you want to talk to another officer, if you want to talk to another prosecutor, or you want to talk to us about questions you may have about the form or anything we covered today, that is part of the help we have available to all of you here in Maryland. Michael?
Yeah, and just a reminder, this is a duplicate from earlier, but just to remind everyone about those virtual roundtables I talked about. Again, law enforcement prosecutor only, very interactive discussions, open discussions in many ways, where we're just getting together and running through scenarios and rehashing some of the things that we do on a daily basis to try to reach our immigrant population in our community. So please sign up for those if you fit one of those law enforcement prosecutor identities, and would be happy to have you on there. And I have to speak to Leslie for the resources. The library is unbelievable. Some of the materials in there, I mean, you're going to find them very helpful. The toolkit's one that I suggest everybody go and download that
Next
PDF,
slide.
take a look at that. And the hotline right there, that hotline, I've used it after hours. And Leslie got in touch with people in DC and here, there, and everywhere. And next thing you know, we solved a very sticky and bad issue in a pretty fast time frame. So I can speak from personal experience that technical assistance line really works.
Yeah.
I'll never forget it, Leslie. So I bring it up every time.
No, it's fine. I mean, that's what we're here for. I mean, we are available to answer questions. We are available if any of you are working with a victim that gets picked up by DHS, call this number, and my cell number is probably everywhere you can find it. I mean, it's 202-210-8886, and call me, because I can call DHS officials in the middle of the night if I have
Yeah.
to, or shortly thereafter to get because they don't want your victims in your cases picked up either. They don't want the perpetrator turning them into a tool that they use to harm your case. So I want to personally thank Tara and Michael for co-presenting with me today. I want to thank Rebecca and Melissa for all your support of this webinar. Please do fill out the evaluation. Let us know about other trainings you'd like to have and what you'd like to learn more about. We're going to be sending you a follow-up email with all of the materials. I was trying, Tara, as you were talking, to stick various materials of case, we've done whole case law summaries and tools for prosecutors on defending against discovery and all of that. So I was sticking some links up in the chat, but we're going to send you materials where you can access all of that by email after the webinar. This is also being taped. And so the materials will have the slides and they'll be taped. So if you have colleagues that you work with at your agencies that may not have been able to join us today, please encourage them to watch the video online. It should be available probably within the week, and we'll get out a link to you. Thank you for everything that you do on behalf of the survivors that you're working with on a daily basis. And I'll pass it back to Tara and Mike to make any final comments.
Thanks, everyone. Best of luck to you. And I'm happy to be a resource for anyone who's chewing on some of these tougher legal issues that come up with these cases.
Yes, same here. Thank you. Thanks everyone for your time and stay safe out there, and thanks for all the work that you do.
Thank you very much. I think Rebecca's going to stop the recording soon.